This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a suit filed in civil court in Texas, among other states, must be prosecuted diligently, and an insured who is suing its insurer cannot sit on a lawsuit just to punish the defendant insurance company and adjuster. Almost every litigating lawyer has tried to get an appellate court to grant a writ of mandate to overturn an error or abuse by a trial court. Successful writs of mandate are as rare as a snowstorm in the Sahara, but they happen. Regardless, Allstate Texas Lloyd tried by a petition for writ of mandamus to get rid of a lawsuit that was not being prosecuted by the plaintiff, where the relators, Allstate and James Stabler, the adjuster, contended that the trial court abused its discretion by refusing to dismiss the underlying insurance coverage dispute for want of prosecution. In re Allstate Texas Lloyd's and James Stabler, the Court of Appeals of Texas on August 26, 2024, surprised all and granted the writ of mandate. On July 13, 2017, real parties in interest Julio and Rachel de la Garza filed suit against Allstate for denying or underpaying their claim for property damages sustained to their home as a result of a 2015 storm. The de la Garzas alleged that Stabler was the adjuster on the claim, and they asserted various causes of action, including breach of contract, violations of the insurance code, deceptive trade practices, and bad faith. On August 10, 2017, the relators, or Allstate, filed their original answer in the de la Garza lawsuit, and on May 3, 2019, 2 years later, Allstate filed a motion to dismiss the case for want of prosecution on grounds that the de la Garzas had not instituted any activity in the case since 2017. Allstate alleged that the de la Garzas had not taken any action to lift the abatement by filing a controversial affidavit regarding their alleged failure to give notice or by providing the required notice, and had otherwise taken no steps to prosecute the case. On June 17, 2019, the court held a hearing on Allstate's motion to dismiss for want of prosecution, and the relators asserted that at this hearing, the trial court ordered the de la Garzas to provide the relators with the requisite statutory notice by July 1, 2019, and that de la Garza did so on July 3, 2019, 2 days late. On December 11, 2023, 4 years later, and many more years since the filing, the trial court set the case for hearing on its dismissal docket. However, no notice of this hearing was provided to the parties. Nevertheless, that same day, the de la Garzas filed a verified motion to retain the case on the docket. On March 22, 2024, relators filed their second motion to dismiss the case for want of prosecution. And on April 24, 2024, the parties mediated the case. However, mediation was unsuccessful, and on April 25, 2024, the de la Garzas filed a second motion requesting the trial court to retain the case on its docket. Aside from filing their lawsuit in 2017 and propounding initial discovery, the only action the de la Garzas have taken to prosecute their case has been filing a motion to mediate on January 21, 2020, filing a motion to retain on December 11, 2023, and engaging in unsuccessful mediation on April 24, 2024. The de la Garzas provided no excuse, much less a reasonable excuse for delay, for any of the time periods the case has been pending. And therefore, on May 1, 2024, the trial court signed an order which granted the de la Garza's second motion to retain the case and denied the relator's second motion to dismiss the case for want of prosecution. And therefore the case went forward to the Court of Appeal on the writ of mandate to order the trial court to dismiss the case. The Court of Appeal noted that mandamus is an extraordinary and discretionary remedy. The relator must show that 1, the trial court abused its discretion, and 2, the relator lacked any adequate remedy on appeal. The trial court is found to abuse its discretion if it reaches a decision that is so arbitrary and unreasonable as to amount to a clear and prejudicial error of law. Mandamus relief is only appropriate when a trial court abuses its discretion. The plaintiff also has a duty to prosecute its lawsuit to a conclusion with reasonable diligence, and if that duty is not fulfilled, the trial court may dismiss the case for want of prosecution. A delay of an unreasonable duration, if not sufficiently explained, will raise a conclusive presumption of abandonment of the plaintiff's suit. This conclusive presumption justifies the dismissal of a suit under the trial court's inherent power. The Texas Rules of Judicial Administration require district and statutory county courts to ensure, so far as reasonably possible, that civil cases in which a jury has been demanded other than those arising under the Family Code are brought to trial or final disposition within 18 months of the appearance date. Many litigants in states other than Texas would be thrilled with such a statute, since civil trials sometimes take as much as 5 years to proceed to trial. Analyzing the issues, the Court of Appeal noted that the de la Garzas filed their original petition against relators on January 13, 2017. Thus, their lawsuit has been pending more than 7 years. The period far exceeds the 18-month time frame for disposition of the cases set forth in the administrative rules. The de la Garzas asserted that the case is set for trial in less than 6 months, and considering the circumstances, they've been reasonably active pursuing this case. In July 2017, the de la Garzas filed their original petition, including requests for disclosures, and in September of 2017, they responded to relators' requests for disclosures. Although the record indicated that the de la Garzas occasionally engaged in brief periods of activity on the case, the record also indicates that there are several extensive periods of inaction. Actions taken after a motion to dismiss is filed, including the obtaining of a trial setting or filing of a jury demand, do not enter into the analysis of whether diligence has been exercised. The de la Garzas' proffered reasons for the delay do not offer a reasonable explanation or otherwise establish good cause for the delay. Accordingly, the Court of Appeals concluded that the de la Garzas failed to prosecute their lawsuit against relators to a conclusion with reasonable diligence, and the trial court abused its discretion by refusing to grant relators' second motion to dismiss for want of prosecution. Relators lack an adequate remedy by appeal, and the Court of Appeals sustained the sole issue presented in this original proceeding and granted the petition for writ of mandamus and directed the trial court to vacate its May 10, 2024 order denying relators' second motion to dismiss and to enter an order granting that motion. In my opinion, many people and lawyers think that if they sue an insurance company for bad faith, the insurance company will open its checkbook and pay off the plaintiff as it demands, without any work. That is not true, and it wasn't true with regard to the De La Garza suit against Allstate. Doing nothing much for 7 years is not just sloth, it is ridiculous, and forced an insurer to file 2 motions to dismiss and move an appellate court for mandamus, a very seldom granted motion, and something it does not like to do. The Court of Appeal granted the petition for mandamus and ordered the trial court to dismiss the suit. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you will have access to the more than 4,800 blog postings. You can also subscribe to these videos on YouTube and rumble.com. They are also free. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, and insurance fraud, please consider subscribing to my Substack publication. Thank you for your attention.